with the video if there were contested issues, and then I would deal with the objection. I'm going to reverse that order. I had an opportunity to review the cases that were, that Ms. Stone alluded to in her argument to me as it related to the objection. I was provided copies of those. I was provided copies of State versus Hager, 171 Washington 2nd, 151, 2011, I believe. State versus Clark, 143 Washington 2nd, 731, a 2001 case, and State versus Young, which is a 1978 case, 89 Washington 2nd, 613. Mr. Larry, did Ms. Stone provide you with those cases or cites to those cases?
I received copies of Young, Hager, and Clark, Your Honor. Yes.
Thank you. Do you wish to offer any further argument?
I do.
Go ahead.
So I think the difference here is, so in Clark, the court holds that when he provided conflicting accounts as to why he didn't follow Lieutenant Heggie's instructions to meet with the detective at the Dolphin House, the key was that he had offered a conflicting account in response to specific questions. And I'm just throwing out, this is on page 28 of 38
Yep.
of our copy. And so then I'm looking at, looks like head note 26. With respect to Hager, I'm looking on page 7 of 10, just above head note 3. Again, defendant spoke to the police on 2 occasions prior to his arrest, gave conflicting accounts as to why he failed to meet with officers at the crime scene as he had promised. And then Young, it was a question as to whether or not he had specific knowledge of the crime, and his questions around specific knowledge. Here, the state, I think, is trying to elicit the fact that she did not provide statements or inquire about her daughter. Factually, we know there's an incident. My client runs to the school. I anticipate that the testimony tomorrow from a witness is going to say that my client ran into the school, was told to leave, and was then said, "You cannot see your daughter." The officers who were in the parking lot talking to my client specifically, this witness never went to the school, never saw Fatima, told my client that she could not return to the school, and never asked her questions. And that's the key thing, is she didn't ask her questions. Tell me what happened. Tell me about your daughter. What did you see about your daughter? Do you anything you want to share with me about your daughter? And so I think that is where it would get into Hager and Clark if there were questions. I mean, this is essentially saying you didn't provide a statement when you weren't asked. And so it's not relevant. I don't think it's fair. I mean, the witness said, I didn't interview her. There was a request to see the daughter, which she was shut down by the detective, by the officer. So there's not a conflicting, like, we asked you what happened, and now you're saying, I saw, a gun. Well, how come you never told us you saw a gun? That's a relevant question where there's a serious breach of, you're now offering some really different testimony, and that's just not here.
All right, thank you. Ms. Stone?
Thank you, Your Honor. Plainly, that's not the requirement of the case law. Clark says that there could be a number of different circumstances, but specifically that when you are talking about when a defendant does not remain silent, and I'm looking at head note 25, which is at page 765 of the opinion. When a defendant does not remain silent and instead talks to police, the state may comment on what he does not say. Then it cites to Young, it cites to Osborne, which is vacated on other grounds. Hager is also addressed as well. let law enforcement, I let defense counsel know of an unpublished case as of recently as 2021, State versus Johnson, which restates the same thing. There is no infringement on a defendant's right to remain silent when they make statements to law enforcement, when they provide a version of events to law enforcement, and they actively do not provide other events to law enforcement. They don't make other statements to law enforcement, especially when one might expect them to make those statements. The rule does not require that questions are asked. The rule does not require that there are, and the case law does not require that there are conflicting statements. Plainly, that is not part of the analysis. It is simply once they have waived their right to remain silent, that opens the door for what the parties can inquire about what was said, how it was said, and plainly what was not said. So in this case, you're right. I believe counsel is right. Officer Chavez did not specifically inquire about the status of Fatima. But what the officers did do is consistently ask everyone present, what's going on? Can you tell me what happened? Can you tell me what's going on? And the only information provided by Mrs. Ali as to those events was what Isaiah was doing to her husband. And she was adamant, and it was repeated over and over again. Not once does she mention what her husband is doing to her daughter. That is relevant, that is significant, and it specifically goes to the interest of Miss Ali during the course of these events. It is notable, too, I would say for the state, that when we are talking about, it's not unfair, it is Mrs. Ali's statements. Mrs. Ali actively engaged, voluntarily engaged. She's not arrested. She is not in custody. It is not any part of any pre-arrest silence. She is voluntarily providing that information because she wants law enforcement to act in a certain way. When counsel argues, well, she was told she couldn't go to the school. She was also told that she couldn't go see her husband, and law enforcement had to continually intervene. She consistently declined to follow their directives. So it is absolutely relevant when we are talking, one, about where Miss Ali's interests were at the time of these events, that is inconsistent with what I anticipate the argument has been or is going to be at closing by defense counsel. It's also inconsistent with the cross-examination questions that counsel has presented during the course of this trial about Mrs. Ali saying, my daughter, as if that was her primary concern. Her interaction with law enforcement says otherwise. Additionally, we have gone through this trial having defense counsel arguing that Mrs. Ali doesn't understand English, that her ability to understand, let's say, the substance of no contact orders and trespass orders is impacted by her ability to understand English. These interactions with law enforcement specifically speak to contrary information to that knowledge, and that she's able to offer the information when she wants to offer information, and she chooses not to when she chooses not to, when that is of import to her. So the inquiries that she actually made about her daughter are relevant. The inquiries that she didn't make about her daughter, and specifically as on direct examination the state elicited, there was no objection, presumably because defense counsel believes it's helpful to them, that did Mrs. Ali say anything about her daughter? Yes, she asked to speak with her for just 1 minute. She asked me a number of times to speak with her daughter, and for just 1 minute, and then sat down. What she never asks, and what we've elicited throughout this trial, is about the condition or welfare of her daughter. Instead, her attention is focused throughout on her husband. So that is not a comment on her right to remain silent. She has waived it, and plainly a pre-arrest silence in this case does not apply. She's not in custody. She's not arrested until days later, and she is voluntarily engaging in offering up information that she believes is important to law enforcement in their investigation in this case. So I would ask the court to deny the objection.
All right, thank you. Anything further, Mr. Lurie?
What I'm just struggling with is the issue in Hager and Young is there's specific questions that they provided misleading answers to, and thus they're then cross-examined. They say, well, you had an opportunity to say this to this specific question, and you refused or provided a conflicting answer. This witness didn't interview my client and didn't say, I want a detailed description of what happened. She describes, that her husband was struck, but there was no discussion, there was no interview with this officer who was just beginning on the force. And so I think it's misleading to the jury to somehow say that it was incumbent upon my client to provide a narrative when not asked by Officer Chavez. And there's body-worn video, and they're not choosing to use it. That would, they're not pointing to a specific point. At this section, this is when she provided a misleading or conflicting answer or an incomplete answer. It's just that somehow she was supposed to volunteer information, and I think that's improper.
All right, thank you. There were 3 questions where there were objections. The first question was, and during the course of that, did she, and this were questions to Officer Chavez related to interactions with Mrs. Ali, did she provide you a statement, meaning did she come to give you a statement? Objection sustained. I continue to sustain that objection. The next question was, during the course of your time with her, did she voluntarily speak with you? Response, yes. Mr. Leary objected. I sustained the objection. I no longer sustain that objection, and I overrule that objection. And that question should be re-asked of the witness, and she will be able to answer that question, whether or not Mrs. Ali voluntarily spoke with her. If and we already actually know that she did because the officer has already testified to some of their interactions and some of the statements that Mrs. Ali made voluntarily to Officer Chavez. And these cases talk about when a defendant does not remain silent and instead talks to police. It doesn't say answers questions asked by the police. It says when they talk to the police, the state may comment on what the person does not say. And that by asking those questions, it is not commenting on a right to remain silent because the person has chosen not to remain silent, and instead has chosen to voluntarily speak with law enforcement. And so in that way, I am going to be overruling the objection and allowing the witness to answer questions. I do not find that violates Mrs. Ali's constitutional right to remain silent, does not violate, really the argument is the state commenting on a right to remain silent because she did not remain silent. Let's address the video if there is an issue as it relates to the video at this point. First, I'll ask, was there an opportunity to review the exhibit that's been referenced this morning? Ms. Stone?
Yes, Sharon, I provided all 3 of those exhibits from Officer Bell's body camera to defense counsel. My understanding from Mr. Leary is that he is objecting to one of them. I'm not sure entirely of the base, but it may, the basis for that objection in terms of what evidence rule. But it may be that he wants to play it for the court first, and I suppose I would ask for clarification from Mr. Leary. That conversation happened literally just before the court. The review of the videos happened while the court was off the bench. The conversation about where Mr. Leary's objections might land happened just a bit before the court came in. So I'd ask Mr. Leary for clarification.
So actually, I'm gonna stop you there, Mr. Leary, because I want to bring Officer Chavez back and conclude. We're at 11:20 and the jury's been in recess for quite a while. Now that I know that it's going to be a lengthier issue and that it could require me to review the video that is being objected to, that's going to take longer. So I'd prefer to conclude this witness, then I can let the jury go for lunch and we can deal with the video issue at that time, and then I will fully hear from you at that time.
I appreciate that, Your Honor. Thank you.
Thank you. Please bring the jury back in. Please get your,
Thank you.
please be seated. Members of the jury, at the time that we took our recess, there had been 3 questions, and there had been 3 objections. I sustained 2 objections, and then on the last question, I didn't rule, and that's when you went for your morning recess. You will not probably specifically remember, nor am I going to repeat what those questions were. I would indicate, however, that as to the second question where I sustained the objection, I've changed that ruling and I'm now overruling that objection. And as to the third objection that I had not ruled on, I am overruling that objection. Ms. Stone, you may continue.
Thank you. Officer Chavez, when we left off, I believe my question to you was, did Mrs. Ali come to voluntarily speak with you?
Yes.
And how would you describe her engagement in trying to provide you information? Meaning, eager, reluctant, something else?
She appeared eager.
Calls for speculation.
Sustained.
How did she engage with you? How would you describe that engagement?
Her initial reaction to seeing me appearing on scene was to approach me and begin to plead or beseech me.
Okay. And during that interaction, who was she expressing her concern for? When you say beseech you, about what? What does that mean?
Would you like me to tell you what she told
You
me?
can ask questions.
I see.
That's okay.
When she initially made contact with me, she asked if I recognized her, confirmed that I knew who she was, and then stated that there had been people punching her husband.
Okay. And did she describe details about what that looked like?
She made the punching motions with her hand.
Okay. And throughout that interaction with her, who, if anyone, throughout the course of the entire interaction, who, if anyone, did she express primary concern for?
Could you restate the question?
Yeah, I'll
Sorry.
rephrase that. When you interacted with Mrs. Ali, did she express concern for her husband?
Yes.
Did that seem important to her?
Yes.
During your interaction with Mrs. Ali, did she ask about the specific health of Fatima?
No,
Did she ever discuss the actions of her husband on Fatima during that period of time?
no.
And how much of your interaction with her was focused on her husband's condition and what Isaiah had done to her husband?
I would say that was her primary focus.
Thank you. I have no further questions.
Mr. Kading, cross-examination.
Officer Chavez, so you got to the scene, you talked to the kids that were out front at the bus stop, right?
Correct.
You never went into the school?
I did not.
And you said you didn't know where Fatima had come from, right?
Correct.
Okay. Did you talk to any of the kids about when Zara arrived on scene?
How do you mean?
Okay, sorry. You can indicate you can't answer, you don't understand, but you can't ask
I
questions.
understand.
Did
I
you-
don't understand the question.
Okay, when the kids you were talking to about what happened, did they tell you when Zara got there?
Not specifically.
Okay. All right, no further questions, thank you.
Thank you. Mr. Larry, cross-examination.
Thank you. So, just to follow up, you had no information about Fatima, correct? In terms of her condition, correct?
Correct.
Couldn't see her, correct?
Correct.
Didn't see what was going on inside the school, correct?
Correct.
Whether she had been seen by the fire department, correct?
Not initially, correct.
What's that?
I did not initially know her condition, no.
Okay. And so, and you never told Zara that you had information about her daughter, correct?
At one point I did, yes.
Okay. As to her condition?
As to her being seen by the fire department,
Okay. Did you have information as to what the results were of that?
I did not.
And did you make efforts on the radio to inquire how she was doing?
I did not.
Okay. So, but in front of her is her husband who's been handcuffed and detained, correct?
Correct.
Okay. And you told her that she couldn't go to the school to check on her daughter, correct?
Correct. I told her she could not go to the school.
Right. So couldn't go to see what the fire department was doing, correct?
Correct.
You ordered her to stay away from the school.
Correct.
And she followed your directive, right?
She did.
Okay. So then her husband has been, from the outward appearance, arrested, right?
Correct.
Right. So he's in handcuffs, correct?
Correct.
Put in the back of a squad car,
Correct.
And she is concerned for him, right?
I
She
would-
appears to be concerned for him, correct?
Correct.
And describing how he had been punched repeatedly in the head, correct?
Correct.
Okay, and that was information that she wanted you to have to understand, you meaning collectively the police, about her husband, right?
I would think so, yes.
Okay. And I just want to be clear, you interviewed the four students you talked about, correct?
I interviewed 3 of them, yes.
Okay. You attempted to interview 4, you were able to interview 3 of them, correct?
Correct.
You did not conduct an interview of my client, correct?
Correct.
You didn't attempt to do an interview of her, correct?
Correct.
Okay. And there were other officers present who said, we will let you talk to your husband in due course, right?
Correct.
And she said, I really want to talk to my husband. I want to know what's going on, correct?
I don't remember her exact words.
Okay. But that was what she appeared. She wanted to communicate with him, correct? All right. Who had just been detained after what she described as an incident where he was punched, correct?
Correct.
Okay. And did you ever tell her that she could talk to her daughter?
I said at some point she would be allowed to.
Did you tell her when?
I did not.
Okay. Nothing further.
Redirect?
Briefly, Your Honor, thank you. When you told Mrs. Ali that fire medics were checking out her daughter, what was her reaction?
She didn't have any specific reaction.
And, but she said she was present when she saw the punches happening, is correct?
She described her husband being punched, yes.
And at the time, her husband was in a police car. He wasn't being dragged through the street or something like that. Is that fair?
Correct.
I have no further questions. Thank you.
Mr. Kading, any further cross-examination?
No, Your Honor.
Mr. Larry? May this witness be excused?
Subject to recall, but yes, please, Your Honor.
All right. You may step down. Thank you.
Thank you, Your Honor.
Members of the jury, I know that this seems a little bit like a habit because I told you we go until noon, but you are done right now for your morning time, and I'm going to have the bailiff lead you back, and you will be in recess until we reconvene at 1:30. Thank you very, very much for your time and attention. As always, please remember all of the instructions that I have given you, and we will see you at 1:30. Thank you. Please be seated. Mr. Larry, why don't you tell me, well, actually, first of all, Ms. Stone, have you had whatever it is marked for exhibits?
I have them all present, Your Honor. I can have them marked.
Okay. That way we can refer to exhibit numbers and be clear about what we're referring to.
Do you remember which one was marked as, Tim? Which one you were? The one. Start that one, please.
We'll know relatively quickly.
What's that?
I'm relatively confident it's
Okay.
that one. I rolled through all three of them, so. Would you like me to make a record?
I was just going to get them marked, and so you can use the exhibit number that they're now marked with as you make your record. I don't know if you'd like to come forward and look at them, so.
All right, so the state has 3 clips from Officer Bell's body worn video. And clip 1 is exhibit 96. Clip 2 is 97. And then 98 for clip 3.
All right.
In terms of the, are you fine with me making this record? Okay. And so the state has provided me with, we had a 52-minute section of body worn video. It's not clear on that, but we know from our discussions that exhibit 96 is 5 minutes and 54 seconds to 8 minutes and 19 seconds on the greater clip. Exhibit 97 is 12:13 to 13:34. And finally, exhibit 98 is 15 seconds long, 14:30 to 14:45. So the first clip is, if I do my math correctly, about 2 minutes and 23 seconds long. The concern that I have with that is there's an extended period of time of my client wailing, kind of yelling off into the distance to what I presume is the officers off camera, detaining Mr. Ali, basically saying, "My husband, release my husband, release my husband." My client is not, and I just pulled this up, otherwise I would have sent this around earlier, so I apologize for that. My client is not charged with obstructing, but State versus EJJ, which, and I apologize, I have not given the state a copy of this. It's a Supreme Court case from 2015, 183 Washington 2nd, 497. And in that case, either a sister, a relative, or a friend of the juvenile was yelling at the officers while they were detaining somebody. And the Supreme Court held that bystanders have a right to yell and project and express their displeasure at an appropriate distance, and that can't constitute obstructing. Not directly on point, but, so my concern here is what the relevance is of her yelling and essentially exercising her First Amendment right to the officers to release her husband. Now, I do appreciate the flip side of the coin, which is the state is going to argue that she was somehow not concerned about her daughter at the time where she's yelling for them to release her husband. The distinction I would make here is that you can do both, and she can still be concerned about her daughter, but what is happening directly in front of her, the detention of her husband, the arrest of her husband, after he had been punched and kicked repeatedly, she has a right to express that displeasure and her concern for her husband's well-being. I don't think that it is consciousness of guilt or consciousness of disregard for her daughter. We know in terms of timing from other witnesses that this occurred after she had already been gone to the school and turned away, which is going to be discussed as a part of the burglary allegation tomorrow. And so as she returns and sees him being lifted, after he's been lifted from the ground and taken, that she is then wailing. I'm concerned at just the length of it. It feels like it's about 1.5 minutes, but we'll be able to actually time it when we play it. So that is my concern. One, it's relevant. Two, it's unduly prejudicial. And I think it comments on her First Amendment privilege right to express her displeasure with the officer's decision to detain her husband. I just don't think that it is sufficiently relevant to somehow suggest that she is not also concerned about her daughter and therefore would be unduly prejudicial.
All right. Let's go ahead and publish the exhibit so that I can watch it.
I'm sorry, Your Honor, may I approach the ground?
Yes.
This is Exhibit 96. Sorry, Your Honor, just needed 1 second.
Just wait right there for right now. I know, and I'm asking you what, You're gonna go to jail. You are gonna go to jail. Let go of my hand. Let go of my hand. No, no. Right here. That's fine, but right now he's being detained for a criminal investigation. And as of right now, until we get to the bottom of this, okay? That's for us to determine. That's for us to stop. Stop.
Ms. Stone, response to Mr. Larry's argument.
Thank you, Your Honor. There's a couple of things that this addresses in terms of relevance. First of all, she's not being charged with obstruction, so while I appreciate the cite that Mr. Leary has provided, it's not applicable to the question that is before the court. I would note too, in that case, EJJ, at least as I recall it, and in my quick recall of it, that sister is yelling at officer as well. The defendant is being detained, and then ultimately the sister is obstructed, is charged with obstruction, and the question was whether that was actual obstruction in that case, and whether essentially there was a sufficiency of the evidence argument as to that behavior. That is not what is presented here. When we talk about this case, first of all, at the time, Ms. Ali was not arrested for that behavior. The officer informed her she potentially could be, but she certainly was not. The officers were trying to engage with her, and you saw Officer Dawes, who was the officer observed on body cam, stepping in front of the women. This is Zara Ali, Hameen Ali, saying, can you tell me what happened, and trying to engage with them, and just the constant yelling, this is my husband, leave him alone, leave him alone. Notably, in terms of relevance, that demeanor and the expression of that demeanor and the expression of how Mrs. Ali prioritized the people in her family on this day specifically was very different for Fatima than it was for her husband. We are going to, I anticipate, see the videos tomorrow from the burglary, for the burglary charge from the Timberline High School. This behavior scene, as it relates to Mr. Ali, is grossly different from the state's perspective than the behavior presented when she goes to get a hold of her child. There is a concern, there is almost a panic here when we observe State's Exhibit 96. That does not appear to be present when she is trying to make contact with her child. So the relevance specifically to demeanor and how she presents here is fair for the state to inquire about. Additionally, throughout the course of the trial thus far, Mr. Leary, and understandably so, but his questions have been focused with witnesses upon how what Mrs. Ali has said to demonstrate caring for her daughter, and who she was worried about during those events. So he has presented that as part of the defense. This is, from the state's perspective, in contrast with that, not just the demeanor, but the forcefulness in which that is expressed. Additionally, there has been consistent argument there has been consistent questioning, and I anticipate argument at the end of this as to how much English Mrs. Ali understands, how she engages with people in English, and whether she can be held essentially accountable for understanding the orders that she has been given. This is a very good demonstration from the state's perspective as to how she engages with English, when she engages, and when she does it for the purposes that suits her. Additionally, during the course of that, certainly she does not come back from being turned away at the office and start demanding that law enforcement tell her about the condition of her daughter. She is only demanding for her husband to be let go. So there's a lot of contrasting things that are happening during the course of this video, and I think it gives the jury a much more fair view of when officers are describing she's upset, she's screaming, she's demonstrating how she's engaging with English. This is a fair representation of that, and it directly speaks in contrast or in rebuttal to the questions that have been elicited by defense counsel. Is not unfairly prejudicial, more than it is probative of what she understands of English and how she is prioritizing the individuals at the scene in rebuttal to what I anticipate defense counsel is going to argue at closing and continue to ask witnesses on cross-examination. Thank you.
Thank you. Mr. Larry?
Well, I think to some extent we're talking about apples and oranges. One, she knows that her daughter is under the care of the firefighters, and the school has directly told her you cannot be here, and I anticipate a witness tomorrow going to reference that I referenced the trespass order that she couldn't legally be there. So her daughter wasn't being arrested. Her daughter was under the care of medical. She had been turned away at the school. She asked Officer Chavez, at some point, can I go see my daughter? Versus her husband being detained after being assaulted, placed into handcuffs, and then taken to a patrol car by law enforcement. And the panic that generates, the two don't equate to each other in terms of, she knows her daughter's being cared for. She knows her daughter stood up, ran away, was conscious, and the testimony of the condition that Dr. Kim talked about this morning, there's nothing that would outwardly, she wasn't shot, she wasn't bleeding, she was conscious, breathing, running away. So, and then in terms of this as evidence of her English, we have the body-worn video from Officer Hang, who talked about, we saw what the interaction was, the question with respect to the no contact order. Her own daughter said that she doesn't read English. So to hear her wailing, saying, my husband, release my husband, release my husband, I don't see how that somehow furthers or calls into question as to whether or not she understands more English than was represented in Officer Hang or in other portions of the videos that I'm not objecting to.
Mr. O'Leary, what is prejudicial about this video to your client?
I think it's just, I'm not sure what it's relevant to, and then, her basically, it's prejudicial because the officer says you're going to jail at the outset, right? And so in terms of when she is approaching and says, I want to see my husband, and he tells her, his response is, you're going to jail. And then her continued, wailing and just basically saying, release my husband, release my husband. I think it's it's unfairly prejudicial in terms of that, you know, that somehow she wasn't taking this seriously, or that, you know, that she felt, I mean, I just don't see what it's relevant of, and then just the wailing over and over and over again, you know, she's incredibly emotional and upset, and I just don't see, I mean, my concern is that the state's gonna say, you know, that she is somehow behaving inappropriately by being upset that her husband has been detained. I think there's also maybe some cultural overtones as she's kind of swaying back and forth. I can't hear what she's saying. It sounds like she's saying something in Arabic. And so I just think I have concerns about the jury taking untoward assumptions about how she's supposed to react, and how somehow she's acting outside the norm as she appears here, you know, in a hijab, as her law enforcement has arrested her husband after he was assaulted. I don't think it's relevant, and I'm worried that it's somehow going to somehow be construed that my client is not acting in a way that she's supposed to, which I'm not sure how anyone is supposed to act.
You cited to the EJJ case and indicated that that was a case regarding a juvenile who was, I think, being arrested or with law enforcement, and then another person who was present was yelling at law enforcement, and then it sounds like, after I heard from Ms. Stone as well, that that person was arrested for obstruction, and then this was the appeal associated with that obstruction charge, and that the Supreme Court said that that person had the right to freedom of speech as long as it really wasn't interfering with what law enforcement was doing with the other individual.
So EJJ is the bystander who is
Right.
yelling, who is then arrested for obstructing. And my concern is that the jury is gonna somehow think that she is interfering, or somehow, even though she's not charged with obstructing, but somehow that she is doing something improper, when EJJ says what she was doing isn't a crime, and you can express your displeasure to law enforcement, and that is entirely permissible under the First Amendment.
All right, thank you. And I would just indicate that is what I understood from what you had previously argued and what Ms. Stone argued as well. All right, so as to Exhibit 96 and the objection as to relevance and unduly probative value. Just a moment here. An argument that if it is relevant, that the evidence, its probative value is substantially outweighed by the danger of unfair prejudice. And I think there was also an argument that this somehow potentially was a comment on Mrs. Ali's First Amendment rights at the scene. First of all, as it relates to somehow impacting her First Amendment rights, that would not be a basis for this to be admissible if it were relevant and not unduly prejudicial. And so I don't find that that's an argument that I would adopt as it relates to excluding Exhibit 96. The first issue as it relates to my inquiry is whether or not this is relevant, and Mr. Leary has argued that it is not relevant, and the state has argued that this is being offered, and the relevance from the state's perspective is that it is evidence as it relates to Mrs. Ali's ability to communicate in English and understand English, and also her demeanor as it relates to her demeanor with concern related to Mr. Ali versus demeanor related to Fatima, which the state has argued is a form of rebuttal to evidence elicited that Mrs. Ali was very, very concerned about Fatima, had called out my daughter, and the like. Clearly there, and relevance is not a high standard, as the parties know. I like to actually read from the rules instead of just trying to paraphrase them. And evidence rule 401 indicates that relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And I do find that based upon the state's argument as to why this is relevant, that it is relevant under that standard. And so then the court must balance, if relevant, whether or not the evidence should still be excluded, if the probative value is substantially outweighed by the danger of unfair prejudice. I asked Mr. Larry about the issue of the unfair prejudice. And before I talk about that, Mr. Kading, I did not ask if you had any argument as it relates to the issues that are being raised.
No, Your Honor. I would note that my client was in the middle of the video being walked through. I didn't see any handcuffs, but certainly he was being detained at the time. I don't know how much we can edit, but I don't think that that's an appropriate scene to have in the middle of the video.
Thank you. Mr. Leary indicated in part that it was unfairly prejudicial. Mrs. Ali was very emotional and upset. He indicated that there is a concern that potentially this could be perceived as something cultural in the way that she was responding to Mr. Ali being arrested and detained, and that there could be untoward assumptions that somehow this was outside the norms. I would just indicate that from the court's perspective, I didn't see anything cultural that was, as far as I'm aware, that was happening. Mrs. Ali was extremely upset. Mr. Ali was being arrested. She had viewed him being significantly assaulted, and she was very, very upset, and she was yelling about that. The court has seen many individuals through the different body cams, now that it's available, who have very extreme reactions to what they are experiencing. And so I would just indicate that I don't think it's outside the norm of how a person can react when their spouse is being arrested and they either don't understand why they're being arrested or don't agree with it. And so I don't find that this is, that the probative value is substantially outweighed by the danger of unfair prejudice. I'm not saying that there's not the potential of some prejudice, but it is not any unfair prejudice. It does not substantially outweigh I find that the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. So I deny the objection. However, there's one thing that I do find is prejudicial, and I don't know how, and overly prejudicial as to any probative value, and that is the statement of the law enforcement officer telling Mrs. Ali that she could be arrested for, I think he said obstruction. He said something, that she could be arrested.
You're going to jail.
Whatever that language is, needs to be, I know that there's an ability to redact that. That needs to be redacted. I know that there's already been testimony from Officer Chavez that Mr. Ali was placed in handcuffs and placed in the back of the patrol car. I believe that came out on cross-examination, but it could have been on direct examination. So I want to hear from Ms. Stone as it relates to Mr. Keating's concern that he raised as to Exhibit 96, when we see that at the start of the video, Mr. Ali, actually don't know that we can see him, but he's clearly on the ground because I see the witness, Mr. Wagner, is kind of in the very corner, and he's still on the ground. And then we see ultimately Mr. Ali up and walks through the video briefly. So I'm going to hear from Ms. Stone on that issue.
Your Honor, before we go on, I'm going to go ahead and unobject.
Okay, withdraw your objection.
Yeah, I'm going to withdraw my objection, Your Honor. I actually, after upon further review, I do not have an objection to that.
Okay,
Thank you.
then I won't address that issue. So the only thing I'm ordering as it relates to Exhibit 96 is removing that portion of the video, or redacting that as it relates to the officer telling Mrs. Ali that she's going to jail or that she could be arrested, whatever that wording is.
Yes, Your Honor.
And then, so then 96 ultimately will not be admitted because we will need a new exhibit that has the redacted information. So it will have a different number, which we will identify when we come back at 1:30. And I want the parties to actually watch the new exhibit once it's been redacted to ensure that there are no issues to the redacting. And I say that only because in a different trial that I had, not with any of these lawyers in the courtroom, something was supposed to be redacted and they thought it was redacted and it wasn't. So I just want to make sure.
Your Honor. Is the court coming back on at 1:30? Is that the intent? I just want to make sure that the parties are in the room timely to be able to do that.
Yes, it's a little bit afternoon, it's 12:02. So we'll recess for lunch. We will resume at 1:30. And what I would like to do is, if Dr. Gilbert is here, we'll take Dr. Gilbert's testimony. Is that what you anticipate?
I need to ask Officer Bell, Your Honor, I apologize. I thought Officer Bell would be done this morning, and so I need to deconflict Officer Bell with Dr. Gilbert. We had anticipated taking Dr. Gilbert right at 1:30. If I can get Officer Bell done shorter and or scheduling allows, I may ask to start with him, but I need to go have that conversation.
All right, so if it's Dr. Gilbert, I just want to bring her in and then we'll deal with the video, the new exhibit, after Dr. Gilbert is done. But if Officer Bell will be called first, then obviously we'll verify the new exhibit with the redaction.
Okay, thank you, Your Honor.
And I don't have to watch it, I just need to know that you watched it to ensure it's correct.
I'll be back at 1:15.
All right. All right, court will be in recess until 1:30, thank you.
All rise, court's in recess.